We're going to go ahead and start. Welcome, everyone. I'm Pam Bridge. I'm from Community Legal Services, and I'm so excited about our guest speaker today. But before we start, let me tell you a little bit about CLS. Can we go to our next slide? CLS is a nonprofit law firm that strives to educate, litigate, and advocate on behalf of our low-income Arizonans. We provide individuals with everything from legal advice to direct representation. But we also do a lot of outreach and know your rights clinics. So if you are with us from an agency and would like one of us to come and do an outreach with your organization, just reach out to us afterwards. Next slide. We are in 5 counties: Maricopa, Yavapai, Mojave, La Paz, and Yuma. However, if you are joining us from one of those other counties in Arizona, don't worry. We have amazing sister organizations that also assist individuals for free. And those two organizations are Southern Arizona Legal Aid and DNA People's Services. Next slide. So what we do, we really focus on consumer education, employment, looking at unemployment, wage and hour, farm worker, and discrimination. Family law, really focusing on domestic violence. Housing, really focusing on tenant rights and foreclosures. Healthcare and economic benefits. We do criminal set-asides, but we don't do criminal law, and we can also assist individuals with federal tax. At the end, I will show you how you can apply for services at CLS, either online, on the phone, or in person. Next slide. This is really exciting for us because today's speaker is been working with our volunteer lawyers program for 31 years. So it's pretty exciting. So I really want to shout out to our volunteer lawyers program that recruits volunteers in all of our counties, that allows our staff and CLS to be able to assist more people than we are normally able to assist. Our volunteer lawyers program in our counties is very robust. We have volunteers who have been working for us for years. They are amazing attorneys in our community. And again, we wouldn't be able to do the things that we do at CLS without our robust and wonderful volunteer lawyers program. Some of the areas that they can assist: bankruptcy, consumer contracts, debts, housing, family law, juvenile law. We have an amazing children's law center, probate, and used cars. You can look on our website for the many areas that our volunteer lawyers program can assist. All right, next slide. So now I'm going to talk a little bit about our great guest speaker, Diane Drain. Diane has been volunteering as one of the VLP program that I just discussed for 31 years. Just a little bit about her. We are in great hands today because she teaches bankruptcy and real estate issues at the Arizona School of Real Estate for 20 years. She's a founding co-chair of the Arizona Consumer Bankruptcy Council. She served on the State Bar AZ Board of Governors for 2 decades. She has received the Lifetime Achievement Pro Bono Award from the Chief Judge Daniel Collins of the AZ Bankruptcy Court. She truly is a bankruptcy expert in our community, so we are so grateful to have her today with us. Next slide. And just a little bit, again, these are public webinars that we are discussing legal information. Diane is not going to be able to provide legal advice, but she can answer questions about legal information. If you want to ask questions, these are generic questions about the law, you can put those in the Q&A. And we will get to those at the end. However, if you have questions about your own individual situation or someone you know, we would ask for that person to apply for services. Again, we'll show you how to do that at the end. And to not put any personal information in those Q&A. But again, if you have general questions over things that she goes over today, please put those in the Q&A and she will get to the questions at the end. Okay, Diane, I am now turning it over to you.
Thank you, Pam, very much. And thank you for asking me to do this presentation. As you mentioned, I absolutely love teaching. This is near and dear to my heart. And as Pam was mentioning, this is a very generic program. This is kind of like taking 10 pounds of potatoes and stuffing them into your baby's sock. There's just so much stuff when it's dealing with bankruptcy. It's not unusual that people underestimate both the power of bankruptcy and the effect of bankruptcy. It can be significant if somebody has received bad advice or just trying it on their own. And my presentation, typically when I'm doing presentations, I'm focusing on one audience. In this case, I'm focusing a much broader spectrum. I'm focusing on people who are just wondering what bankruptcy is and whether or not this is something they should investigate, people who are professionals and coming in helping out at VLP or CLS, what is basic bankruptcy, etc. So really, it's intended to be a much bigger picture across the board. So that's why you see these warnings here. And in 40 years that I have done this, I have never met a single human that had the identical same financial situation as another human. So at the very least, if you're looking for advice and somebody is just giving you generic answers, that's not helpful. Yes, you need generic, but you need specifics based on your very unique situation. And that should not come from some paralegal. That should come from the attorney. All right, so why bankruptcy? There are just so many basic life-changing events that happen for people, and this is an opportunity for folks to get a true fresh start. So the top ones are always medical, job loss, divorce, and business failure. You see here a list similar to that. So something traumatic has happened in this person, this family's life, that leads them now with no other recourse but to figure out how bankruptcy might help them. And it's not a commitment to filing, it's just how can it help? Bankruptcy is a constitutional right. It's been written in our Constitution since the 1800s. So I have people call me and say, I'm just so embarrassed and I don't want to file, but I can't figure out anything else. And I have to, my business card says attorney and counselor. Counselor, because I'm saying to them, hey, breathe. You didn't choose to lose your job or have a heart attack. It's an event that has happened in your life, or most times it's not unusual. There's a multiple series of events that happen for people. So different types of bankruptcy, and here we get kind of lawyery, but I just want you to understand that when someone uses the word bankruptcy, they're not necessarily talking about one pathway. There's two basic pathways, whether business or personal. And first is you get to keep baseline stuff that our legislature has decided is necessary: clothing, furniture, your puppy dog, a small car, things like that. And they're called exempt property. So that's the first clue that you want: a copy of the exempt property for the state that you live in, presumably Arizona. Now, there's some rules in bankruptcy, though. In order to use Arizona exemptions in a bankruptcy, you have to have lived in Arizona for more than 2 years. Otherwise, you use some other exemptions. So it's not like you're going to lose your puppy dog because you're filing bankruptcy. And then the other type of bankruptcy is a reorganization. And in essence, this is where you take things you have that you want to fix, like you're behind on your mortgage, or your car is really upside down, or you owe back taxes, child support, alimony. Reorganization allows you to get the umbrella, the protection from your creditors by filing a bankruptcy that then you continue to pay certain things like I want to keep my house, well, then continue to pay on it, but I want to get rid of my credit cards, no problem, unless it was fraud. So you get rid of your credit cards. So that's where liquidation, whatever valuable stuff you have that is not exempt, so that 8-carat diamond ring is not going to be protected in bankruptcy. If you have an 8-carat diamond ring, file a Chapter 13, you pay the value of that ring over time. We have different players. Of course, the number one player is the judge. To tell you the honest truth between you and me, I failed if I have to go to a judge. That means I didn't give my clients good advice from the beginning. Something got screwed up. But that doesn't mean I haven't been before the judges. It just means I feel personally that I could have done something better to avoid having to bring a judge into the picture. The clerk of the court, so it's a managing organization for the bankruptcy court. Every bankruptcy has a trustee. I call it the babysitter. Now, that's probably a little euphemistic, but anyway, that's the person whose job it is to review the documents, to make sure that the debtor who is filing is being honest and is following the rules. So we have the Department of Justice has the U.S. Trustee's Office, and then there are Chapter 7 and Chapter 13 and Chapter 11 trustees. I'm here not talking about Chapter 11s, that's commercial. And then, of course, we have our player, that's the person who filed bankruptcy, or it could be an entity. So consumers are you and me. Commercial then would be businesses who are filing. And sometimes people cross over where they're a human who is filing a commercial bankruptcy because they have a business. And then, of course, the respective attorneys. Not everybody uses an attorney. I get calls all the time saying, well, it's just filling out a bunch of forms, so I really don't need an attorney, do I? And I say, no, just like you don't need a doctor to do open heart surgery. Might be smart for you to at least talk to somebody and see if what your situation is. Hence, you know, depending on your income, community legal services. If your income is too high, I started a self-help center at the bankruptcy court back in 2005. So it's the Arizona Bankruptcy Court Self-Help Center. And we have a fabulous gal over there that manages that. Your duties or the debtor's duties. Bankruptcy is not a game. It is a very, very serious matter. And there can't be anything left out. Bankruptcy is all encompassing. Everything you own, even things you want to pay, it has to be listed. Everything you owe has to be, so everything you own, everything you owe, any transfers you've made, payments you've made to friends and relatives. There's time periods on filing documents. Yes, you can, for 98% of those, you can ask the court for permission for extra time to file. But if you don't ask the court, your bankruptcy is gone. I just had a foreclosure call yesterday where somebody didn't follow the rules, didn't file their documents. And so their bankruptcy was dismissed and their house was foreclosed. And I have to say, you know, anyway. There's two courses for the consumer, you and me. There's two courses. One you take before filing. You do it both of them online. Second one after filing. There's you've got to provide copies of tax returns and decide whether you're keeping the car or not. A lot of different duties that you have there. And it is very, very important if the trustee or the judge or your own attorney asks for something. Respond. Don't ignore them. They're not going away. What can end up happening is that your bankruptcy is dismissed. That's not the end of it, though. You will have a bankruptcy on your credit for the next 10 years, even though you didn't finish it. This is the reason why people file for bankruptcy. I call it almost the most powerful tool known in the United States, the automatic stay. And it basically is like an umbrella that drops over the top of the debtor and the debtor's stuff. And with few exceptions, it covers everything. It covers the debtor, their stuff. It stops outside creditors from being able to foreclose. Doesn't mean it's permanent. It just means it stops it. It stops the phone calls, the garnishment of wages. Basically, it puts a stop to all actions that are going on. You'll see two exceptions: criminal prosecution or collection of child support. So the automatic stay is not something to ignore. If we flip the coin here and make that you are owed money and somebody files bankruptcy and you think, I don't have to pay any attention to that. Well, be aware that you do, and there's going to be serious economic consequences to your ignoring this federal restraining order saying you cannot call, write. You can certainly bring legal action, but you cannot call or write or demand payment. And even the IRS has to honor this. Okay, bankruptcy does get rid of most debts. So let's just say 98% of your debts bankruptcy gets rid of. But there are some that it doesn't get rid of. It might manage. If you're in a Chapter 13, you're paying back support, alimony, child support, maybe paying back taxes. If you're in a 7, those don't get paid. You're responsible for them. A secured creditor, two types of creditors. One, that would be the creditor who has a loan on something you own, like your car, your house, your furniture. That's called a secured creditor. And they're treated special because they've got collateral. That's the car, furniture, your house. And if you don't pay them, it is highly probable that they will go take whatever their collateral is, even though you have filed bankruptcy to get rid of your obligation to pay the debt, but doesn't allow you to keep the vehicle without paying for it. Two different things there. The remaining of the creditors are called unsecured creditors, and those are ones that rarely ever survive bankruptcy. Credit cards, medical bills, personal loans, so those kind of debts, or things that maybe they're secured, but you don't want to keep them anymore. So you can give back the car and get rid of both the debt and the car. Now, the estate. What is the estate? The estate is your stuff. We call it the bankruptcy estate because when you file, you create this entity that has all of your things, including your puppy dog, is part of this estate. Now, out of that estate, things can be carved. And that's where you get back to those exemptions. Certain things in your estate are exempt from creditors touching, including the bankruptcy trustee, even though they try to touch it occasionally. And then Arizona is a unique state. There are 9 in the union called community property states. And what that means is any debt incurred while married belong to both spouses with just a couple of exceptions. So I get calls all the time where wife is saying, well, these are all my debts, so I'll file bankruptcy so that my husband doesn't have to file. And I say, oh, I understand, and that's certainly a right. But let's talk about what community property law is and how your husband is actually affected by your bankruptcy. And depending on circumstances, could later, like you move out of the state, you pass away, or you get divorced, that person who didn't file bankruptcy is liable for the debts, even though the other one filed. So community property is important. Stuff you gave away, sold, traded within 2 years prior to filing bankruptcy, that could be brought back into the bankruptcy estate. So if you thought you got away with something by giving your sister that Mercedes, no, you're not. If it was done within the 2 years prior, the bankruptcy trustee can bring it back into the estate. If she paid fair market value, that's different. There's also a sidebar note on that, and there's a 4-year look back for transfers made under state law. Money that you repaid family or friends, there's a 1-year look back for that. And then inheritance. So something that we always have to determine when someone is filing bankruptcy is, do they expect an inheritance? And then explain to them the consequences of an inheritance. Here's a little more in-depth details on what a Chapter 13 is. Now, I'm going to start from the bottom, because the bottom is the most important thing here. A Chapter 13, number 1, is a 3 to 5 year commitment. Number 2, it has a 50% failure rate, and that's even with using attorneys that are good at their job. Why, you say? That's because you're human. And human beings have change in life. And as a result of the change, you no longer have the income you did, or you've lost your health insurance, and now that's a problem. You've gotten divorced. There's 7 more babies in the house. Whatever's going on, life changes for humans. But the fallacy with the 13 is you draft a document called a plan at the very beginning of the 13, and it basically predicts what your income will be and what the payments are you're going to make over the life of the plan. Well, how the heck do you do that when you don't even know if you're going to have a job a year from now? But that's how a 13 works. Hence the failure, the 50% failure. And so a good experienced Chapter 13 attorney, in interviewing their clients or potential clients, will look at the long range issue with the short range version of where they are today and what the benefit is, et cetera. There's a lot of math that goes on into figuring out, should you even try and file a 13. Our bankruptcy court tells us that those who try their own 13, it's less than 2% ever are successful. So you can see here a list of the things that a 13 is used to do. Pay back taxes. Some older taxes actually go away. Pay back alimony, child support. Maybe you're behind on your house, and now life has gotten really good. You've gotten back to work, but you've got $20,000 behind on the house. So you can use the 13 to bring that house current while you keep it current. If your vehicle is worth less than what's owed and it's more than 910 days from when you financed it, you can pay the value of the vehicle rather than the full debt. Okay. If property, say your house, has a mortgage, say a fourth mortgage, on your house, it's possible we can get rid of that using the Chapter 13, because the house is worth less than all the secured debts against it. Divorce has some things that go on, like property settlement agreements. Those don't go away in Chapter 7s, but in Chapter 13s they do. But you'll notice my note there, alimony nor child support go away in either 7s or 13s. Foreclosures, repossessions, those can all be put on hold. It doesn't mean they stop. They're still going on behind, especially foreclosure is still being postponed behind the scene. It just means you've got that automatic stay that won't allow the creditors to go after the house, as long as you stay current and you've got a good solid Chapter 13 plan. We do have a model plan and a stipulated order confirming plan. So in other words, what that says is that there are some forms that we have that we lawyers have to use too, along with you. The chapter, the discharge. This is really, I call it the golden ticket, because everybody, that's the reason they file bankruptcy. They want to get rid of their credit cards, their medical bills, personal guarantees. Maybe they want to get rid of a car that's now become a real loser of a car, and just get rid of the car, get rid of the debt, those kind of things. So the discharge is what is discharging the debtor's legal obligation to pay the debt. I mentioned earlier, if you have a loan on a house and you're not paying that, a discharge isn't going to get rid of, it isn't going to allow you to keep the house. It will get rid of your legal obligation to pay on the house. Hence, the lender can't sue you once they foreclose, but they can foreclose. So the discharge is very, very important. Unfortunately, 50% of everyone you talk to, even lawyers, think that's the end of a bankruptcy. It is not. It's just halfway through. I have these flow charts that show people how this works. And the discharge, I have a big sign on my email I send my client that says, almost there. And that's my subtle way of saying, you're not done. Don't ignore me. Keep working with me. Now, chapter 13, actually to finish on the 7, if you get the discharge, it's not unusual, unrepresented debtors or those not represented by very good attorneys, they get the discharge thinking they're all done. And then the trustee, of course, is asked for their 2024 tax return. And they think, well, no, I've got my discharge. I don't have to give you anything. And they walk away. And then all of a sudden, they start seeing a bunch of noise going on where the court is threatening to revoke their discharge. So anyway, chapter 13, the discharge comes in at the end of the plan. I say it's anywhere from 3 to 5 years, just depending on a whole lot of other factors. And here's my big note. It's not the end of the bankruptcy. The bankruptcy must be closed in order for it to end. So, number one, only after the debtor has done all their duties, and that includes whatever the trustee asked you for. Then the trustee has forms they have to do. The U.S. trustee, that's the supervising agency, the police of the bankruptcy court, basically, that also supervises the trustee. They sign off, and only then does the court close the case. But this is big, should be in red, huge, huge font that says, if the debtor failed to list an asset or there was a change in their pre-petition rights, which mean pre-petitions before the petition, then this case can be reopened. And one of the things that we have seen over the last 30 years is a whole bunch of class action lawsuits. They all seem to be coming out of Texas. For faulty medical devices, et cetera. Well, those class action lawsuits went on for decades, and now all of a sudden they're being settled. Well, what's happening then is these people who filed their bankruptcy and it was closed some number of years ago, if not decades ago, are getting notices that their bankruptcies are all being reopened. That's to deal with this financial distribution that the debtors their estate has now received. So as far as the overall perspective of how bankruptcy, what's important in bankruptcy, how in real estate, the realtor will tell you it's location, location, location. In bankruptcy, it's disclosure, disclosure, disclosure. When I'm talking with a prospective client, and they ask me after we've had a discussion, well, do I have to tell the trustee? I say, that's strike one. And then I go on and I answer their question. Okay. And then if later in that same discussion, they come back and say, well, but mom could say that she just gave us the money. She didn't, whatever, the story was. Strike two, you're fired. You're out of here. Because what they just told me is that even though I'm telling them what the law is and what their responsibilities are, they're thinking they can game the system. And I never want one of those people to be one of my clients. And once I have fired them, that's the end of it. I don't care what they promise to do. I don't care how much money they offer me. End of story. You don't game this system. And for the attorney who plays games, they're screwing they're messing with their reputation because it's a small community, very small community. The courts all know who we are. There's only 7 judges. They all know who we are. They know our reputation. They know whether to trust us when we stand up in court and swear to the truth of what our clients say, etc. And the same is true for fellow attorneys. The same is true for the U.S. Trustee's Office and for all the Chapter 7 and 13 trustees. So anyway, my point is that the discharge is half of the goal. The second is closing the file. Now, the closing of the file could actually take a while. There are two types of bankruptcy, and I don't have these delineated in the slides here. Number one is called a no asset case. That's my goal. Everybody, I want to be able to file a Chapter 7 that everything they own is on the exemption list. Hence, there's no assets that are not on the exemption list. That was a double negative, right? Okay, so if they own something that is not on the exemption list, they now have become an asset case. Now, the process that they use, the filling out of the documents, etc., that's all the same. But a no asset case typically runs time-wise. Day 1, file bankruptcy. Day 35, attend a meeting with the trustee. It's a short little meeting called a creditor's meeting. That came from the 1900s. Usually for consumers, creditors aren't there, but the trustee is, and the debtor's asked to swear under oath that everything on the documents is true and accurate. They listed all their debts, no exception. They listed all their assets. And then the trustee goes through some various questions. And so that's usually day 35, typically around day 110, 120. Here comes the discharge. And again, to remind you, that's not the end of it. If it is a no asset case and it's a trustee, not all trustees are created equal. It's a trustee that is managing their files well. They get assigned several files regularly. Then usually the trustee will file their final report of a no asset case within maybe a month or so of the discharge. And then the court sends stuff to the U.S. trustee, who then signs off, usually within a few days. And then the court sends out this notice to the debtor's attorney, not to the debtor, saying your case is now closed. In our office, we now send an email to our client with fireworks on it saying, yay, you're done. So anyway, an asset case, though, same process. File, go see the trustee day 35 or so. Discharge comes day 110, 120-ish, somewhere along in there. But then the trustee starts doing work. Now, why would the trustee want to do any extra work? They get paid money. They get paid 25% of the first $5,000 they collect and a depreciating amount thereafter. They could make thousands of dollars off of liquidating non-exempt assets. So that's why a good attorney warns the client before the case is filed about what should we do with assets that are not exempt. You can't hide, or, you gotta disclose whatever you do with them, but they need to know what's going on. So it's an asset case. Now the trustee has maybe real estate that needs to be sold. How long is that going to take? Well, it's real estate located in Kansas. They got to go hire somebody in Kansas and then, of course, find a buyer. And so a year or two later, here comes the buyer, here comes money. That case is still open through that whole process. The discharge is in place, but the case is still open. And it's not unusual as far as other assets. Some of the trustees, we got people that are trustees, and people have difference of opinion. We have a few people, trustees, who feel that if they could just make an extra $100 off the debtor, they're going to make them do all kinds of things. That's not a normal trustee, but unfortunately we have a few here in Arizona. On the opposite end of the spectrum are the guys who say, unless there's $1,500 worth of stuff that's not exempt that I can collect from the trustee, I'm just going to file my no asset report. Those are our favorite, obviously. Those are the ones that we want to get, but we can't choose who we're going to have as a trustee. when filing a bankruptcy. So anyway, the asset case can turn into, a year, 2 years, 3 years while it stays open. And there's a lot of legal issues about what's appropriate and what's not. But just warning, heads up, uh, when someone tells you you have an asset case, you might see what can I do in order to make it not an asset case. Again, beware, disclose, disclose, disclose. Your paperwork, minimum of 60 pages, has to fully detail everything you have done in the last, period of time, whatever the question is. Okay, so final notes here. I already mentioned that I have the word counselor on mine, and that is because people call me and they're positive they're not going to be invited back to Bridge Club again because they had to file bankruptcy, or their family, they hide. Kids call and say, no, I don't want to tell mom and dad, or vice versa. Mom and dad call me and say, no, I don't want my adult children to know what's going on, kind of thing. And I explain how we can deal with all that. But they're just so embarrassed. They see it as a failure. Well, are they the ones that caused the car accident that now they have $250,000 in medical bills from a car accident that some drunk caused? Are they the one that caused the collapse of the business and they no longer have a job? Are they the one that, just because they're 65, they can't find a job once they lost their other job? Are they all of these events, stuff happens. And so we always want to remember it's a constitutional right, but it is not just filling out a bunch of forms. It's knowing the history of this person, where they're coming from. My initial questionnaire before I even accept them as clients is 7 pages long, just asking yes and no type questions to see what it is they need to do before they even think about bankruptcy. So do your homework first. You won't see the phrase honest but unfortunate debtor in the bankruptcy law. It's called the bankruptcy code, but that is basically what you will see through so many of the bankruptcy cases, that term. I say never game the system. And if you're ever talking with a professional, a doc prep or an attorney who tells you something that sounds like gaming the system, walk immediately, because you are going to be the one to bear the burden for the lies that they're telling you to do, because you're the one that signs 9 or 10 places on your bankruptcy documents that everything is true and accurate. They are not going to show up in court and say that, yes, they told you to lie about that car that wasn't licensed, whatever. Okay, and I was a law professor for 20 years, and I would teach my law students that bankruptcy is one of the few areas of law, if not the only area of law, that requires the bankruptcy attorney to understand every single other area of law. Normally, people can say, I'm a divorce attorney, and they have no idea what real estate law, other than a little bit for theirs, what probate or anything has to do. They just do divorce. Bankruptcy, we have to know it all. And some attorneys, so when I was teaching my law school class, they'd come in and I would ask them, okay, I want you to write down what you think about bankruptcy. In one sentence, what do you think that bankruptcy is, or one paragraph, what bankruptcy is all about? And generically, they would basically say, it's just filling out a bunch of forms. All right, now fast forward to the end of semester. I asked them the exact same question. Now I've saved their answers. And I asked them, now, what do you think about bankruptcy? 100% say, I had no clue. I had absolutely no clue what all was involved and all the depth. And the most underpaid attorney out there is the consumer bankruptcy attorney. For the amount of hours they spend with their clients, they might be getting paid $15, $20 an hour at the most, which is certainly less than what the Circle K guy gets. Anyway, and unfortunately, what happens with these mass production firms, the internet advertising type firms, they take people in and they take their money. It's hard sale to get people to sell or to sign the contract. And then they do just basic low, bottom feeder type of work. They file that with the court. The somebody, the creditor, the trustee, starts then coming after the debtor saying, well, how about this? How about this? How about this? And then the debtor says, well, I was told, I always said that was okay. And the attorney then says, I'm leaving. And they remove themselves from the file, leaving the poor debtor to have to take care of all of these things. Okay, lastly, then community legal services, fabulous for those that are on extremely low income, but most folks are not. And so again, back to the Self-Help Center, it is at the bankruptcy court on the 6th floor. I think they're still there. Truthfully, I've been to the court three times since March of 2020, COVID, because everything we do now is on Zoom. And so I think they're still on 6th floor. But anyway, they are certainly on their website. So if you go to AZB, as in Arizona Bankruptcy, .US courts, COURTS, US courts.gov, GOV, there's a link there for the Self-Help Center. And you can then ask to talk with an attorney, and Tammy Johnson, the gal in charge of it, will put you in touch with somebody. So that is it for my, again, I apologize. I know this was really, really, really quick, and I crammed a whole bunch of potatoes into your baby's sock, but at least you have an overview. So I'll turn it back to Pam if she wants to, if we have any questions.
Sure. Let me, if you can go to our next slide, we had a couple questions about how to apply for services that I've answered privately, but I'd like to tell everyone that you can apply for services at CLS by calling us 9 to 2 at these numbers. They are also on our website. If you would like to come in person, can go to our next slide. We are all over Maricopa. If you're calling from our rural offices, you can call the rural office directly. Otherwise, if you're here in Maricopa County on Tuesdays, we're in Peoria. Wednesdays, we're at Native Health at Indian School in Central. And on Fridays, we are at Mesa. And that's it. Thank you so much. I think if you have more questions, we are out of time, but you can always email CLS for general questions. And if we don't know it, we will reach out to Diane and ask her for her help. I'm really thankful for you, Diane. I learned a lot today. This will go on our YouTube channel so that we can see it later. If you would like to get a link to this or any further questions, you can also email me at pbridge, as in Pambridge, pbridge@clsaz.org. All right, thank you so much. Again, I'm so grateful for your time today.
You're very welcome. Sorry for the sidebar into the politics. Please,
it's all good.
just clip it out.
All right.
All right.
Thank you.
Okay.
Thank you, everyone.